The word significant, which the Honourable Lady seeks to introduce, carries a meaning that is widely understood in court and which a judge could adequately describe to a jury. It is not an extremely high threshold. The word proposed by the Honourable Lady is not, for example, substantial. And the concept of a significant contribution will depend on the individual circumstances of the offence. I contend it would be perfectly feasible for lawyers for both prosecution and defence to put arguments to a jury so that the jury, properly instructed by the judge, could determine whether or not there had indeed been a significant contribution to the offence by the defendant. And I would just point out on the use of this word, significant, it features throughout sentencing guidelines which are used by all courts in England and Wales. Indeed, it is used in the sentencing guideline for murder, where considerations judges should take into account consider, for example, whether there has been a significant degree of provocation or a history of significant violence or abuse towards the offender by the victim. Now, I know that in the case of this particular legislation, the government has some concerns over the term significant. They are justifiable concerns. They're ones that need to be fully addressed and considered and thought through. So I hope that the Honourable Lady might consider pausing the progress of her bill today to allow for that full consideration to be undertaken so that we can end up with a situation where we have legislation on joint enterprise that will definitely work in the way that she rightly intends.